Today's topic is Indian judiciary. Judiciary is one of the three organs of the state. The function of this organ of state is dispensing justice based on the law of the land and other associate laws deriving its essence from the constitution of the country. Montesquieu, a French philosopher, gave the concept of triparty system for separation of power of the state. Montesquieu described the breaking down of power between executive, legislature, and judiciary. In the system, there is inherent character of checks and balance between the three organs. Therefore, separation of power is based on the responsibilities of the state into distinct branches and also limiting the powers by clearly defining their premises. In this way, the concentration of power and its misuse is avoided at all costs. The Indian judicial system is derived from English law of jurisprudence. It is based on precedents, customs, legislations, and codification of laws. The Indian judiciary is a single and integrated judiciary system for whole of India. At its apex stands the Supreme Court and at state level are high courts. Other courts work under the High Court. In this way, the judiciary is independent. The Indian judiciary, since its inception, has come a long way by evolving and adopting itself to various circumstances. The year 1861 was a landmark year in Indian judiciary. It was in this year that the high courts in Kolkata, Mumbai, and Chennai were established. Also, with Macaulay's efforts, the Indian Penal Code, criminal procedure codes, etc., were laid, which the modern court applies with while dispensing justice. On 26th January 1950, the federal courts gave way to Supreme Court of India under the Indian Constitution. Articles between 124 to 147 of the Constitution describes the various features of Supreme Courts of India. Supreme Court at present has provision for Chief Justice of India and 30 other judges. Similarly, High Courts of States derives its power from Constitution and works under the Apex Court. District Courts of India are established by state government and work under High Courts. Some other innovations at grassroots judiciary are Lok Adalat or Nyay Panchayat, which acts as a mechanism for alternative dispute resolution. Also in 2008, Gram Nayalays were established as mobile courts dispensing swift justice for people. One very important feature of Indian judiciary is its independence. The constitution provides for appointment of judges by president, qualification for appointment of judges, difficult procedure for removal of judges, adequate power and functions of judiciary, etc., that makes the judiciary independent. However, in order to preserve its independence under the three judges case starting from 1981 in the SP Gupta versus Union of India case, Supreme Court advocates on record association versus Union of India 1993 case, the collegium system was put forth. The system was in principle to secure for itself any executive interference in judicial appointments. But over the last 2 decades, it became a matter of discussion as there was no transparency in the system. In order to bypass the opacity in the system, 99th constitutional amendment was passed. According to it, National Judicial Appointment Commission was constituted with stakeholders from judiciary, executive, civil society for making appointments to the judiciary. However, the constitutionality of commission was challenged and in 2015 the 99th amendment was quashed. However, the apex court advised to bring transparency in the system. Similarly, another landmark in the judiciary was the basic structure doctrine. The doctrine was given in the famous Keshav Anand Bharti case, although there is no exhaustive list for basic structure. But Supreme Court has reserved for itself to expound on this doctrine. With its various judgments, it has described basic structure as supremacy of the Constitution, rule of law, separation of power, judicial review, etc., among others. Judicial review was another idea of basic structure that the apex court reserved for itself. Judicial review is the aspect where it acts as the final interpreter of constitution. The Supreme Court therefore has its power to determine the constitutional validity of any law that gets enacted. In its pursuance of judicial review doctrine, it quashed 99th Amendment Act, another area of concern in Indian judiciary in pendency of case and understaffed organization. The famous quote, justice delayed is justice denied. Over 3 crore cases are pending in Indian courts with 65,000 in front of Supreme Court, 45 lakh in front of High Court and 2.6 crores in the subordinate courts. As a consequence, it has been estimated that an under trial accused can spend almost 9 months without any substantial progress in case before getting a bail. The Law Commission has suggested 40,000 judges to be increased and 50 judges for a million people. At present, India has 17 judges per million people, making it highly understaffed. At times, it has been observed that whenever the other organs of state do not function well, then judiciary steps in. This is called judicial activism. But there exists a very fine line between judicial activism and judicial overreach or judicial adventurism. In other words, judicial activism is going beyond the normal constraints to judiciary by striking down legislation or instead of passing a legislation disguised as judicial orders. Over the years, Indian polity has seen increasing role of judiciary in the political process. The mechanism of checks and balance is required to restore balance between different organs of state. It is true. True freedom requires rule of law and a system in which rights of one are not secured by denial for rights to the others. Thank you.